Hi everyone, welcome to the webinar regarding working with detained immigrants. This is Tina Mansouri. I'm a supervising attorney here at NIJC.
Good morning, everyone. This is Andrea Ochoa, and I'm the Detention Project Coordinator here at NIJC.
And we're going to talk to you today about how to work with an individual who is in ICE custody and defending them in their removal proceedings.
So we've had a lot of interest in potential pro bono attorneys, as well as the community in general, on getting to know how to work with people in detention. So we created a roadmap from the time that we identify someone in detention to when they get released, as well as common challenges. So we're going to talk about who is in detention, where they're being detained here in the Chicago area, how are people coming into ICE custody, and then we're going to go into the most common questions that we get from pro bonos. When will my client have court? What happens in court? How do I prepare a case with a detained client? And what happens after the merits hearings, as well as the common challenges. And then we're going to have some space for questions if you have any questions after we go through all the program. Okay, so people who are in immigration detention that we place with pro bono attorneys are, for the most part, individuals who have been harmed, tortured, or who fear harm or torture in their countries of origin. And for those of you who are familiar with this terminology, we're specifically talking about asylum seekers. We also, however, see other type of individuals that are in ICE detention that we normally handle in-house, newly arrived undocumented individuals who have lived and worked for the United States for years, and some of them are cancellation eligible. Some of them also have something in their criminal background and are eligible for other forms of relief. We also see long-term lawful permanent residents who come into ICE custody either because they're transferred from criminal custody or because they were sent to ICE detention at the port of entry. And on occasion, we also have United States citizens in ICE detention. And usually that's the case for those individuals whose parents naturalized before they were 18. They were under the care of parents, and we actually recently found one, and you can see a little bit more about that case online. And just as a quick reminder for those of you that just joined, if you have any question, feel free to type it, and we'll see the questions type, and we'll get through them at the end of the presentation. So where are individuals detained coming from? For the most part, the majority of people that are currently in ICE custody are from Mexico. However, people that are being represented by pro bono attorneys come from different parts of the world, mainly from Central America, Mexico as well, Africa, Asia. So we have a variety of nationalities of people that we see in ICE custody. How old are they? It varies. We see unaccompanied immigrant children. The majority of people that we see in ICE custody are young individuals between the ages of 18 and 35, and the majority are male. And we also on occasion see older individuals. Some of them have mental health issues, criminal backgrounds as well. So it varies. What type of claims we usually see, it also varies, but for the most part, those cases that we see for asylum seekers involve gang recruitment, domestic violence, forced military conscription, and as well as other types of claims. In the Chicago District ICE detention, meaning the purview of the Chicago Immigration Court, there are 8 detention centers. Some are in Illinois, some are in Indiana, some are in Wisconsin, and we have one in Kentucky. The newest detention center is in Kankakee, which is about an hour and a half away. It's called Jerome Combs Detention Center. It recently became also a processing center, so we're seeing a lot of changes in that facility. For McHenry County, which is the first one listed, and there it has capacity for about 200 people. It's about an hour and a half away from Chicago. Broadview is not an overnight facility. It's about a half an hour away from Chicago, and we usually, and it may change in the next coming months, but we usually have individuals being brought to Broadview for forensics evaluation if we see that it would be beneficial for the judge to understand the claim better. We also have Pulaski County Detention Center, about 5 or 6 hours from Chicago. Clay County, which is about 2 hours, and it has capacity for 50. Kenosha, which is about 2 hours from Chicago and has capacity for 200. And we have Dodge and Boone, which have similar capacities and are usually people that are apprehended in those states. How can I check where my client is? There's 2 ways. One is, and it's online, where you can check locator.ice.gov. If you have the individual's alien registration number, which is also known as the immigration number, and you know the country of birth, you could search it that way. Or if you have the full name and the country of birth, you could also try that way. Sometimes if you have the full name, try if there's 2 last names, try with 1 and with 2, and hopefully you'll have a match. When you find your client or your prospective client in the locator, it's going to show what facility they're at. And if you click on that facility, you're also going to find the address of the facility as well as the contact information for the facility. This is a common question that we get, which is, can my client be released from custody? And the answer, it depends. Some individuals are apprehended at a border, which makes them only eligible for parole. And unfortunately, we've seen with the new administration that ICE rarely is granting parole. We also see individuals with prior removal orders, which are not eligible for bond, which means that they have to stay in detention during the duration of their proceedings. And we also see individuals with certain crimes that make them not eligible for bond. And now now Hina's going to explain to you what actually happens once the person is detained.
Okay, so how is it that individuals get detained? First of all, the immigrant gets apprehended either by ICE or by local police, often after a traffic stop, when they have a criminal arrest. And if they're apprehended by the local police, oftentimes once they're done in state custody, ICE will have placed a detainer on them, and they will then come into ICE custody. However, some people are also picked up directly by ICE without contact with local law enforcement. Sometimes individuals may have applied for a benefit with immigration, and at their interview, they'll actually be detained by ICE because they have perhaps a prior removal order. And most commonly for our purposes, we see folks who are getting detained at or near a port of entry. So ports of entries are basically, there's 2 types that we're talking about. One is airports, international airports, where an individual has flown in and then encounters Customs and Border Protection at the airport. And then otherwise, there's also land borders, so the Canada-U.S. border or the U.S.-Mexico border. Somebody may stand in line at Southern California or at the Texas-Mexico border to seek admission into the United States, or they may try to sneak into the U.S. by crossing the river or climbing the fence to try to get in. Most of the time, folks in those situations are apprehended fairly quickly, and they are then taken into ICE custody. And even those individuals who, voluntarily present themselves to immigration, saying that they want to seek asylum and trying to do it the lawful way rather than sneaking into the U.S., those individuals are also just automatically taken into custody where they await a credible, fair interview and then go through court proceedings. And finally, we also see individuals who get detained through ICE enforcement sweeps. These are becoming much more common in the new administration, though they have always taken place, even in the Obama administration. So once an individual has been arrested, they are taken to be processed, and ICE runs their fingerprints. They do a bunch of background checks through national databases, and they interview the individual regarding their immigration history, their family ties, and very briefly regarding whether they are afraid to return to their home country. They don't do a full-fledged asylum interview at this stage. It's pretty brief, just basic information that ICE gathers. And oftentimes, we'll see inaccuracies in the records that they produce out of this processing. So after that, if the individual is eligible to see the immigration judge, they will then be placed directly in removal proceedings, which are called 240 proceedings. That's the section of law under the INA section 240. Some individuals aren't eligible automatically to see the immigration judge. However, individuals who have prior removal orders on their record or who are subject to some form of summary removal will not be able to see the immigration judge unless something else happens first. For the most part, those individuals would first need to have an interview with the asylum office to determine whether they have a credible or reasonable fear of persecution and thus should be entitled to see the immigration judge and apply for asylum. So there are a few different types of summary removal orders that we see. So reinstatement is when ICE reinstates a prior removal order for somebody who was ordered removed, actually departed to their home country, and then re-entered the United States again without permission. Those individuals, that prior removal order from their prior time in the U.S. just gets reinstated and used against them again. And those folks are not eligible to see an immigration judge unless they express a fear of returning to their home country and pass a reasonable fear interview. Another type of summary removal are expedited removal orders. So expedited removal orders apply to those folks who are detained either at a port of entry, so again, the land border or the airport, or who are detained within 100 miles of the U.S.-Mexico border and who cannot demonstrate that they've been in the United States for at least 2 weeks. Those individuals automatically get removal orders and don't have the right to see the immigration judge. Their only recourse is if they express a fear to return to their home country, in which case they will be referred to the asylum office for a credible fear interview. So credible and reasonable fear interview. So first of all, what's the difference between the two? So anyone who has an expedited removal order, so those individuals who do not have past immigration history before coming to the United States this time, they would go through a credible fear interview. Individuals who have prior removal orders, who were deported and then came back again, those folks will go through reasonable fear interviews. The main difference between the two interviews is that the standard is a bit higher for reasonable fear interviews, and the reasonable fear interviews tend to be more extensive than the credible fear interviews. But other than that, the process works the same, and the way that you'll see the documentation of the interviews will look the same as well. So what happens, a person is taken down to the asylum office in Chicago, where they meet with an asylum officer and have an interview. If they need an interpreter, the interpreter is available over the phone. There's never an in-person interpreter there. After the interview, the person is taken back to the detention center, and at some point later, either a few days later or sometimes even a couple of weeks later, the person is called back down to Chicago, where they receive a decision on their credible or reasonable fair interview. It will be either a positive decision or a negative decision. A positive decision means that the person will then be allowed to see the immigration judge and pursue their claim. And they will be given a packet of documents by the asylum officer. It will include basically the asylum officer's worksheet that goes through the basic biographical information they gathered from the person and goes through, why they thought, whether they thought the person met their requirements to have a colorable asylum claim. And then there'll also be a transcript, which is basically the question and answer of the interview that took place. Now, this isn't a verbatim transcript. Really what's happening is the asylum officer, when they're interviewing the person, they just summarize the answers, the questions that they ask, and the answers that the individual provides. There's nobody recording and transcribing the interview word by word. So you will normally get these things when you get a case from us because we'll have received them from the client. You want to make sure that you review them carefully because sometimes you'll see that what a client has said in that interview will differ from what they subsequently say, and you want to try to figure out why there might be any inconsistencies, if there was a language issue, so on and so forth. Okay, so once somebody passes their interview, they are then placed in court proceedings, and they will go before the Chicago Immigration Court. So when you get a case from us, we'll tell you when the next court date is. However, sometimes court dates change, and you always want to make sure that you have the most up-to-date court date. Sometimes you may forget or not know whether it's a 9 a.m. hearing or a 1 p.m. hearing. You can always call this 800 number to find out what time your client's court hearing is and with which judge it is. So it's an automated number. You just call it, you punch in the person's A number, and it will tell you when, where, and who. One note on the judge is that these days, while previously one judge would normally follow a case from beginning to end, because the court is trying to get through detained cases really quickly, they're scheduling cases differently and having some judges handle all of the master calls, which are the status hearings, and then having other judges do back-to-back merits hearings. So the judge that you have for the master calendar hearing may not be the same judge that you have for the individual hearing. So your client will not physically be in court for the master calendar hearing. Rather, they will appear via video teleconference from the detention facility where they are being detained. Each of the facilities has video teleconference capability set up where the individual goes into a small room, sits in front of a computer screen or television over which they see the courtroom. The way that it's set up, they cannot see the entire courtroom in Chicago. They'll only be able to see in one direction, and you'll be able to see when you're in the courtroom at 525 West Van Buren which way the camera is facing, the camera that's sitting on top of the TV in the Chicago courtroom, and be able to tell whether it's facing towards you or whether it's facing towards the judge. The default is usually that it's facing towards the judge. So your client probably won't see you sitting there in court for him unless the judge turns the camera. However, you will be able to speak into your microphone and your client will be able to hear you. Because of this setup, you really aren't going to be able to speak to your clients confidentially. before their hearing, before, during, or after their hearing. So generally, we recommend that any communication that needs to happen beforehand, that you schedule a call just to go over any of that stuff with them before the court hearing, and that you also schedule a call for shortly after the hearing so that you can review with the client what happened at the hearing and answer any questions that they have. Otherwise, in emergency situations, if something comes up and you need to talk to your client confidentially during the court hearing, you can ask the judge and the government attorney to leave the courtroom so that you can speak with your client, but I would only reserve that for exceptional circumstances. Okay. So getting prepared for court, if you don't already have an EOIR ID, you will need to get one. So you will need to e-register for an ID and then go into the immigration court on Van Buren to get an EOIR ID number by showing them your government ID. And once you have that, you'll be able to fill out your E-28, which is the court appearance form, and file that with the court. It's okay to do that on the day of the first time you're appearing in court. I would just make sure to be prepared with the three copies of your appearance form so that you can just fill in your EOIR ID manually on each of the 3 copies while you're in court without having to handwrite all 3 copies. Another thing you want to do before court is you want to review the full case file. So that's everything that we send your way. We will have spoken with the client, we'll have notes on the client's case, and we'll have documents that we will already have gathered from the client as well. And you should review all of those things so that you're as familiar as possible with the client's case. Included in those documents should be the notice to appear, which we'll talk about now. So the notice to appear is a charging document that begins proceedings in immigration court. This will apply to any case where the individual is in regular 240 removal proceedings. If you have a client who had a prior removal order and was subject to reinstatement of removal, they will not have a notice to appear. Those individuals will be placed in special proceedings called withholding only proceedings, and there won't be any NTA to plead to. However, in most cases where it's just regular removal proceedings, there will be an NTA, and you will want to see whether your client, while he was pro se, already pleaded to it, or whether you need to plead to it when you go to court. So the NTA is basically divided into 2 sections. The first section has factual allegations, and the second section has legal charges. So the factual allegations will be things like you are not a citizen or national of the United States. You are a citizen and national of Eritrea. You presented yourself for inspection at San Isidro on March 3rd, 2017. You didn't have a valid visa. So those are just facts, and assuming that all of those facts are correct, you can go ahead and admit those allegations. For the most part, they usually are correct, but sometimes you want to double check dates, as I sometimes messes up the dates. The legal charge will generally be a charge that your individual is present in the United States without having been inspected, or that he is seeking admission to the United States but does not have valid documents for admission. So you can also concede that that legal charge is correct, because in fact that is true for our individuals. They don't yet have valid status in the United States. The judge will then ask you whether you want to designate a country for removal. As a matter of practice, you should decline to designate a country, and this is just because, as a matter of principle, your position will be that your client cannot safely return to his home country, so you don't want to offer up that country as a place that he can return. Once you have declined to designate, the government attorney will generally designate their country of origin, and the judge will mark that country as the country for removal, and that's fine. It's really just as a matter of practice. You don't want to be the one who's designating yourself. Okay. So you'll also want to file the I-589 asylum application in court. If you have taken on a case and the hearing is coming up quite soon, and there really isn't sufficient time to have the I-589 prepared for your first time in court, that's okay. I would go into court prepared to plead to the NTA, but you can otherwise request a continuance and have another master calendar date to file the I-589. I would only do this in situations where it's been maybe less than 2 weeks or less than 10 days since you took on the case. If it's been any amount of time more than that, you should be able to get the I-589 together and file it with the court, particularly since you'll only be filing what we call a skeletal I-589, just sort of a bare bones form that fills out all of the biographical information and includes a couple of lines in each of the substantive sections, but you don't really need to go into a whole lot of detail. You don't need to include supporting documentation with the application. Really, you just want to have enough information on there to give the judge and the government attorney a sense of what your case is about. So as with everything that you file with the immigration court, you're going to need 3 copies. The original goes to the judge, a copy to the DHS attorney, and then 1 for yourself. Everything gets double hole punched at the top. This goes not just for the I-589, but anything at all that you ever file with the immigration court. You will want to hand the judge's copy and your copy to the bailiff who's in the courtroom. The judge will stamp your copy and the bailiff will return it. He'll keep the court copy. You'll want to hand the government copy directly to the government attorney who is sitting across from you. Once you go on the record, you pleaded to the NTA, you filed the I-589, the judge will then set the case for an individual hearing. And usually it's about 4 to 8 weeks out. If the judge offers you a date that's too soon or that doesn't work with your schedule, you can ask for a different date. The judges do try to be accommodating. However, do keep in mind that the judges are under a lot of pressure right now to expedite detained cases. So the chances of getting a date much longer than 2 months out are pretty slim. And, keeping in mind as well that the judges who do detain cases understand that there are going to be time limitations. The judges will understand that having less time to prepare a case will affect what you can gather and put together for the case. So I wouldn't stress about it, the fact that the hearing could get scheduled soon. Okay. Here's some other common questions that we get. So I just wanted to go through those. First of all, interpreters. The court will provide its own interpreter. The court has contracts with certain in-court interpreters who work at the court and appear in person. Those are usually Spanish language. And otherwise, they contract with some language lines to provide phone interpretation for other third languages. The court will not let you provide your own interpreter. So even if you prefer your own interpreter to whomever the court may use, you won't be able to choose to use your own interpreter. It will have to be the court interpreter. However, if you have an interpreter that you've been working with and they want to come to court and sit in to make sure that the court-provided interpreter is interpreting accurately, you're welcome to do that. Again, 3 copies of everything, double hole punch everything. There's no e-filing except for the E-28 form. maybe one day the immigration court will catch up technology-wise, but so far it's still everything on paper. So you will be killing a lot of trees with your immigration court filings, unfortunately. Master calendar hearings, generally each hearing is pretty short, but how long you will wait in court for your hearing will depend on a few different factors. What happens is a bunch of individuals are all scheduled for one morning or one afternoon with a judge. So it's a master call, and it's basically the cases could be called in any order. Generally, attorneys will sign up and the judges will try to go in order by the sign-ups. However, because the judges are shifting between BTC at different detention facilities, sometimes they'll want to finish all cases at one facility before moving on to another facility. And if your client is unlucky enough to be at the facility that the judge gets to last, that could mean that you end up waiting in court for up to a couple of hours. So I would suggest taking reading material with you in case that happens. Reading material on paper, not in an electric form, because those bailiffs in the courtrooms are cracking down on any use of technology by attorneys, aside from the government attorneys, unfortunately. Okay, so preparing a case. So there are a few different ways to communicate with your detained client. The primary way that we communicate with clients is over the phone, and that's because the detention facilities are so far away. And it's perfectly fine if all of your communication with the client is over the phone. If you have any possibility of getting out to the facility, perhaps one time before the individual hearing, that would be great, but it's also not expected, particularly if you have a client who's down at Pulaski 6 hours away. It's understandable if you're not able to make that trip down there, as it would basically require an overnight trip and having to find lodging, etc. So, if your only communication with your client is over the phone, that's fine. And the facilities here allow us to set up scheduled calls with individuals that are confidential calls. And we have a full instruction list for all of the facilities that's on the registered users tab of the NIJC website. We're also happy to email that to you if you need it. When we send you a case, we'll include the information for the facility that your client is at the moment we give you the case. However, sometimes the client will be moved and then you'll need the information for another facility. So the facilities are also in the Stone Ages, and while you would think it would be easy to just email a facility to set up a call or send documents, etc., for the most part, communication to set up calls, to send documents to your client will take place via fax. So all of the facilities have fax numbers, and there are procedures for getting documents to your client that you want them to sign, for having them send documents to you, and for requesting a call time via fax. Some of the facilities are not willing to let you send faxes of documents or receive documents via fax from your client, and that will be noted on the facility list, which facilities don't allow that. And for those facilities, you'll need to take more time to prepare in advance to have time to mail back and forth or FedEx if necessary. Okay, so as mentioned before, when we were talking about what to do before you go to court, you want to make sure that you review the case file thoroughly, and IJC will provide you with our database notes from the individual, which will include all of our past conversations with the client, and those are definitely helpful to review, so you know what the person has already told us, what types of things we addressed with them, and what we haven't. And you will want to make sure to look at that and before you talk to us about any questions that you have, because the answers may already be in the case file. Okay. So when you prepare the case for the hearing, you will want to put together both a pre-hearing statement, also known as your brief, and index the supporting documentation with the supporting documentation behind it. Generally, these things will be due 15 days before the individual hearing. However, the judge may set a different deadline if he thinks that he can accept a filing closer to that final hearing date. And if you think that having a little bit more time for your hearing, for your filing rather than the 15 days would be helpful to you, particularly if your hearing is getting scheduled very soon. I would definitely recommend at the time that the judge schedules the individual hearing to ask whether he would consider taking your filing later, such as perhaps 10 days before the individual hearing or even a week before the individual hearing. Most of the judges are pretty good about that. And even if it's not set up in advance, the judges will normally accept motions for late filings if you have a good reason, such as that you are still working on obtaining documents from abroad, etc. So there are different things that you will want to piece together for your filing. The most important thing will be your client's affidavit that you will work on with him or her. There are two ways to basically put together an affidavit. One is to just completely work on it with your client by question and answer, interviewing him, and then typing up your affidavit from scratch. Another way, and this tends to work better with clients who have a slightly higher education level, is to have them take an initial stab at their draft, put down all of the information that they think is important, and then use that as the starting point for your draft, and then follow up with them to gather any missing information and clarify any points from what they wrote. Another time where it might be helpful for the individual to write out things is if they are just having trouble remembering, and if they have time to sit down about it, they'll be able to put down their thoughts more coherently. And sometimes people who have faced trauma, may not want to express themselves out loud as easily, so they may prefer to write something down as a starting point as well. In addition to the affidavit, you'll also want to get supporting and corroborating affidavits from any other potential witnesses. So this can be individuals who know the person, who can talk about, corroborate their identity, corroborate that they're a good person who would merit asylum. And then, especially importantly, anyone who can write something that would confirm parts of your client's story, you want to try to get an affidavit or a statement from them. Because your client is detained, you should be primarily in charge of working to get those documents rather than counting on your clients to reach out to people from inside detention. It's much easier for you from the outside to contact individuals and to have documents mailed directly to you rather than having your client try to coordinate things from inside detention. In fact, we've often seen when somebody gets packages sent to them to the detention facility, oftentimes they aren't allowed to be delivered to the individual. There are complications. So it's just much better if you coordinate all of that directly. In addition, you will want to put together a country conditions index with all of the articles and reports attached to it. This will be all of the documentation, all the factual documentation that regarding the country that supports your argument for why your client is eligible for asylum, and there's sort of a delicate balance between not including enough or including too much. You definitely don't want to throw in the kitchen sink and put in every single report written about your client's country of origin, relevant or not. There may be lots of bad things happening in your client's country, but a lot of it may not be relevant to your client's claim, so may not be necessary to include. However, maybe you find a report directly on point to your client's situation. That's definitely something that you would want to include. And if you have any questions about how much to include, whether to leave something out or not, definitely feel free to reach out to us, and we can help guide you through that process. Let's see. Additionally, we say here cover letter, but really what we're talking about is the pre-hearing statement. That will be your legal memo going through the elements of asylum and explaining why your client qualifies. And then at the end of your filing, you will want to make sure that you have a certificate of service as well, so that the court doesn't reject the filing. In terms of where to file, you will file it at the immigration court window at 525 West Van Buren, and you can electronically serve the government copy on the government via email. Okay, I'm going to turn it back over to Andrea. Hold on, we're still on me. Hold on 1 second. Okay, what happens during the individual hearing? Okay, so at the beginning of the hearing, usually the judge will talk to you and to the government attorney to make sure that you're all on the same page and that everyone has received each of the relevant filings. If you have anything additional that you want to submit the day of the hearing, you can submit it at this time. If there are any last-minute corrections that you need to make, such as to your I-589 or your client's affidavit, you would want to go through those at the beginning of the hearing as well. The government may, if they have anything to file, they may file it last minute at the beginning of the hearing as well. Government usually doesn't comply with the 15-day filing deadline and usually just brings in anything they have the day of the hearing. Once you have done that, the judge may ask you for a short opening statement. It's up to you whether you feel like you want to give context for your client's testimony before he begins to testify. Otherwise, you can waive the opening statement and move directly to direct examination. The judge will swear in your client, and then you'll be able to start your direct examination. The judge may interrupt the direct examination if he has any questions he feels important during the hearing. Most of the judges don't interrupt very frequently. The one exception is Judge Vinicor, who will basically try to hijack your direct examination. But for all of the other judges, you should be fine to just pause while the judge asks his questions and then resume your direct examination where you left off. After direct, it's the government's cross, and then after that, you will have a chance to redirect your client. So you can do any redirect that you have at that point. And then after that, the judge may have some more questions. He'll ask them, and then he'll turn to both you and DHS for closing statements. The judge will hopefully be able to make a decision on the same day, and he could, if the government's not going to appeal, he could just, say something short and issue a summary decision. If the government indicates that they may wish to appeal, he'll have to issue either a longer oral decision or do a written decision that will come to you in the mail at a later point. Or if there's just no time at all and the judge wants to think more about whether to grant or deny, the judge may actually continue the case to another date to make his decision, or may tell you to just expect a written decision in the mail with his decision.
So you're done with the case. What happens after you finish the merits hearing that you've been preparing for? There are a couple of things that could happen. The first thing is that the immigration judge decides to deny release, in which case check in with us after you reserve appeal so that we can brainstorm on what is the best course of action to appeal. If the immigration judge grants relief, then ICE could release your client that same day. So it's important to make sure that you go over all potential scenarios with your client before court. So make sure that you set up a call, not only to prepare him or her for testimony, but also to run through the potential scenarios that could happen if the judge denies or if the judge grants. We have seen common post-release issues, one being housing. So the client, of course, is expecting to be released that same day. That doesn't necessarily happen, but if it does, then it's important to make sure that the person has where to go that night. If you have been in communication with a relative or a friend during the course of you preparing for the case, make sure that they're also on board on how are they going to get to where the person lives. So the people that we accept don't necessarily have their relatives here. They're detained here. But some of the family members that they're reuniting with can live in California, in New York, and all parts of the country. So it's important to make sure that you arrange transportation with the family members. For the most part, the relative is able to either purchase the train ticket or the bus ticket. Because they're not going to have passport, it's going to be very challenging for them to get on a plane. So we highly discourage that. So that means that the person is going to be, after they're detained for some time, in either a train or a bus. Other post-release issues include health. So as you can imagine, the person that you're representing has been in detention for some time and probably was in transit to get to the United States for a couple of months as well. So we've seen either people losing a lot of weight or gaining a lot of weight, depression issues. So it's important, or high blood pressure. Some people are getting medication for that. So it's important that they have a plan of action. You're not responsible for their health, but it's important for them to know, okay, if I get released, how am I going to make sure that I get by for at least a couple of days. Usually when the person is getting medication, I release them with a week of medication. So that's a common question that clients have. But it's also important, if you're in communication with a deportation order, to make sure that the health needs of your client are met as well. We have worked with an amazing organization called Interfaith Committee for Detained Individuals, also known as ICDI. They help us a lot in post-release logistics. They have a hotline, which you can see in the PowerPoint is 312-985-7740. If you have a merits hearing coming up, make sure that you call the hotline in advance so that you can pre-arrange if the person wins and is going to be released. They're going to also help you plan if they have capacity and they have a strong network of resources available to people that are being released from detention. We also want to highlight that the population that we serve and that you're going to serve have special challenges that you need to take into consideration and be mindful of when you're representing a client. The first one, the most obvious one, most of the clients don't speak English or are limited English proficient individuals, so there's going to be a language barrier. There's also going to be a cultural differences. So for instance, if you're representing a woman that has is a survivor of domestic violence, it's not going to be as easy to spot instances of harm because perhaps what she has known as rape is not it doesn't translate to what we know as rape. So it's important to take into consideration those cultural differences. We've also seen that abuse is not spotted by client, either because they block it as a mechanism, a defense mechanism, or because they have never spoken about it. And that links to the third point. Many of the people that you're going to, for the most part, all of the people that you're going to be working with are survivors of trauma. They probably are undiagnosed they haven't been diagnosed with post-traumatic stress disorder, but they show a lot of symptoms that a person that is diagnosed with PTSD, with post-traumatic stress disorder, has. So sometimes they can't sleep well, or they're very anxious. They can't remember the dates correctly. They switch the dates and the order of events. It's not necessarily because they're lying. It's because it's hard for them to remember the details. And as I mentioned before, detention conditions is also something that we take into consideration when we're representing clients, and we also encourage you to do that as well, because clients are in prolonged detention. There are mental and physical health challenges associated with prolonged detention. If you have any questions, or if perhaps you don't know how to respond to a particular situation, you can flag it with us. We have experience with this population, so probably the question that you have is a question that we ourselves had at one point. So we're happy to go to walk with you on making sure that we respond to these conditions appropriately. Logistically, there's also difficulty setting up calls with some of the facilities, so be patient. Sometimes the fax doesn't get through. Sometimes even though you send the fax, they don't receive the fax. So be patient with them. What I usually do with some of the detention centers is that after I send the fax, a couple of hours later, I call just to confirm. If you have, so for instance, McHenry County Jail, you can just call and schedule a conference call. That's easier, but not all of the facilities work that way. And lastly, you may be the only person that the individual is talking to outside of detention. So make sure that you set up expectations clear. If you say that you're going to call him or her on Tuesday at 3, make sure that you call him or her at 3 p.m. Just treat them as you would normally treat any other client. And something that we usually do, as Hina mentioned before, involve your client in the process. Leave them homework or things that they could do while in detention. They have a lot of time in their hands, and they want to be part of their process. So we usually tell them, start with your story. It's going to take more than one time for you to remember things. So it's okay if you write it tonight and then 2 days after you go back to that incident, okay? So make sure that you leave activities or tasks that they can do while they're detained so that they can also feel empowered. And that's going to be crucial, particularly when they are released. Other challenges that we also see are confidentiality issues. So make sure that you clear confidentiality with the people that are also going to be part of the case, specifically family members, okay? So with family members that you're in contact with, you're going to have a variety of experience. Some they don't understand why you can't do it for them. But also the chances of them getting, for example, a birth certificate or a death certificate, it's going to be easier for them than for you. So again, explaining how crucial their role as family members is. But also make sure that you explain who the client is. You're representing the person in detention. You're not representing that person as your client, the relative. So make sure that they understand that, and you owe confidentiality to the person that you're representing in detention. And also set the clear deadlines and clear timelines so that you're not running at the end of closer to when your merits hearing is. At NIJC, we call technical support for any type of question that you have while you're preparing the case. If you take a pro bono case with us, you're going to be assigned to an NIJC attorney. The NIJC attorney or the coordinator of a project is going to answer questions that you have, any issues that you have by communicating with your client. We're also open to reviewing affidavits, motions. If you need a sample of a motion or a document or an expert, or you want to set up a forensics evaluation, we can guide you and point you in the right direction. And lastly, we also want to encourage you to watch a separate webinar, which is the asylum webinar. If you are currently representing an asylum seeker, it's important for you to get acquainted with the elements of asylum. The asylum team prepared a really interesting webinar, so the link is there. It's about 2 hours, so make sure that you review that. On occasion, it's very helpful, not only for you, but for all the team members that are working with you on the case. And we also have a registered user section. It's only available for past and current pro bono attorneys. If you sign up, because we have a large volume of people that are signing up that are not necessarily pro bono attorneys, make sure that you email us so that we can activate your username. And that's our working with detained individuals training. If you have a question, you can type it up, and we're more than happy to answer.
Yeah, we're not seeing any questions so far. I'll give it a couple of minutes, and if you have questions that you want to type in right now, we're happy to answer them.
And just as a pitch, and if you're watching this after April 14th, today is April 14th, we have currently 4 cases that are waiting for pro bono representation. So if your firm or you are an attorney who's interested in taking a detained case, you can email us and we can explore the possibility of you taking on a case. Okay, so if there are no questions, thank you very much for joining. We're, of course, available if you have questions after. And thank you for joining this webinar.
Thank you, everyone.